Hello, everybody, and welcome to Law and Society. Today, we're going to do a compare and contrast between Judge Aileen Cannon and Judge Tanya Chutkan. And what I'm going to do is both these judges have issued certain orders, and things are going to get more and more legal and confusing, and uh, I'm going to do my best to keep up with them. My main focus will be the January 6th election interference. And on that note, by the way, Jack Smith is still subpoenaing people investigating on January 6th and Donald Trump's election matters. This investigation seems to be focusing on his Save America PAC. I wouldn't be surprised if we have wire fraud, uh, you know, charges coming up. That's sort of a tangential matter. So what I want to talk to you today about is Tanya Chutkan and Aileen Cannon. Tanya Chutkan has been expediting and fast tracking the DOJ versus United States versus Trump in the election interference case, like any federal judge should be doing with a case of this importance. There's a public interest in a speedy trial. And while constitutionally there's a defendant's right to a speedy trial, here Donald Trump wants to do the exact opposite. But in the interest of justice and in the public interest of having a speedy trial, DOJ has been ready to go with the discovery process at any given time, whenever the judge allows it, and whenever the defense comes to an agreement that Donald Trump will not share discovery materials out of context on social media. So Donald's defense, as recently as this weekend, has not committed to saying that, which means that they're saying that we can't promise that when we get discovery of these things that we're not going to post it on Truth Social and publicize it and give it our spin. And that would, at its core, destroy the integrity of the prosecution of the evidence. It would give Donald Trump the ability to take names on social media and attack witnesses like he has been with Mike Pence, because Mike Pence's position in this case is clear. So, I hold on a minute. So here we have Judge Chutkan ordering to set the hearing for the protective order that DOJ has asked for Friday, August 11th at 10 a.m. Eastern Time. Now, mind you, had the defense stipulated and said that we are not going to share discovery material outside of the case, we will only do it, we will only use discovery as it should be used, as an information for their defense, so they may be able to build a defense at trial, not to take those discovery pieces and put them out of context and put them on Truth Social and have a trial of public opinion. That's not how the judicial system works. So Donald Trump's attorneys didn't want to have a hearing this week and said that they weren't available until the 14th or the 15th. Judge Chutkan clearly did not take that into consideration when she set it for August 11th at 10 a.m. And this protective order has been sought by DOJ because they believe that Donald Trump will use discovery materials to compromise the integrity of the case by sharing it with the public out of context and outside of the confines of the trial and the courtroom. So, you know, and courts don't want a criminal case to be adjudicated in a court of public opinion. So, when this hearing happens, I predict that Judge Chutkan will allow both parties to make their arguments, and then she will set a very narrowly tailored set of protective orders of what Donald Trump can and cannot do in the context of this case. It by no means will be stopping him from getting to social media or stopping his speech like he has lied and claimed on Truth Social. What it will do is that it will stop him from talking about Mike Pence and other witnesses in this case. And as the discovery materials, and which include witness testimonies and other evidence, is turned over to them, defense and Donald Trump will have knowledge of the names of all the witnesses. So if they don't commit, which they haven't and which they won't, to publicly releasing discovery material, evidence, and witness testimony before the trial happens, and jeopardize the integrity of the trial and completely destroy the possibility of having a fair jury trial, because now it's public knowledge and put into the context that Donald Trump wants to put it into, as opposed to it being a criminal trial. So this protective order is for that. I don't think that the protective order is going to say, yeah, don't attack me, meaning Judge Chutkan, and don't attack the prosecutors, because that would seem trivial, and that is not, that's where free speech comes into play. And unless he's directly attacking them, which he's getting very close to, but he's also being very careful about, it wouldn't be something that would be winnable on appeal, or at least I'm talking about if it goes to SCOTUS, with where we have SCOTUS right now. I'm not just talking about the DC Circuit. So Judge Chutkan will impose a narrowly tailored protective order restricting Donald Trump for speaking about witnesses in the context of this case, talk about discovery materials being presented to them in the discovery stage of the pretrial, and then leave it at that, because I don't think that Judge Chutkan wants to politicize it anymore. Now, on the flip side of the spectrum, we have Judge Aileen Cannon. And before I go into Judge Aileen Cannon's current, delay, let me remind you quickly that when the investigation on the Mar-A-Lago documents began, and Judge Magistrate Bruce Reinhart issued a search warrant for Mar-A-Lago, Donald Trump filed a case in Aileen Cannon's court to have a special master review. And Aileen Cannon, before getting a reply from the government, replying to the special master review, said that she was inclined to grant the special master review during the criminal investigation. That case was slammed by the 11th Circuit, who put Aileen Cannon in her place. And as fate would have it, after the investigation happened, after all of the things that Aileen Cannon was blocking with the special master issue happened, the case has come back to Aileen Cannon, and that is random. That is district court randomness and fate. So what Aileen Cannon has done is most recently has put a spotlight on the DOJ for continuing its investigation into the Mar-A-Lago case and set the Department of Justice's reply deadline for August 22nd. And pertinent part, Judge Cannon ordered that the response shall address the legal propriety of using an out-of-district grand jury proceeding to continue to investigate and or to seek post-indictment hearings on matters pertinent to the instant indicted matter in this district. So, in this matter, briefly, I will say that nothing in the indictment showed, and at no point did Jack Smith say that his investigation into the Mar-A-Lago documents and of other people, of other linked to this is over. And I'm not an expert in that, so I will direct you to X, formerly Twitter thread of Andrew Wiseman that explains why Judge Cannon's order is out of line. Please read it. And I put the link for Mr. Wiseman's thread in the description of this video. So I urge you to read it, and you will ask yourself, well, is it an appealable order? Is this substantially altering the course of this particular prosecution, this case? Is it outcome determinative? It's a borderline thing that she's doing. She has broad discretion to do this. But what she's essentially asking Jack Smith is, why are you continuing the investigation? And why are you having out of district grand juries? And, Mr. Wiseman explains that grand juries can happen where the crime took place. And if the crime took place in New Jersey or the crime took place in DC, that related to this case and related to other defendants, then Jack Smith will go where the evidence goes. What Aileen Cannon and Donald Trump seems to be arguing is that they are going into out of grand jury proceedings to find evidence for this particular case in front of the judge, which is not the case. The evidence that is set forth in front of the judge is the evidence set forth in front of the judge and in the indictment. And should additional material be available through other investigations happening into other people regarding criminal acts they committed in connection to Donald Trump, then that additional information and evidence will be added to discovery. That is how proceedings work. But here, Aileen Cannon would like a response. And, Mr. Wiseman explains it much better in greater detail in his X, formerly Twitter, thread. So I urge you to go and check it out. Now, these two judges are the spectrum of the district court that we are seeing. Judge Tanya Chutkan is an Obama appointee who is in the DC district court, and Judge Aileen Cannon is a Trump appointee who is in the Southern District of Florida, I think, in Florida. So Aileen Cannon has shown, and the 11th Circuit previously has admonished Aileen Cannon for her abuse of discretion. There has been no order. On the other hand, there has been no order that Judge Tanya Chutkan has issued thus far that could be appealable. And here's a compare-contrast disparity, while Donald Trump has gone out of his way to publicly demand Judge Tanya Chutkan's recusal from the case of election interference, he has only praised Aileen Cannon for her, rulings and her adjudication of the Mar-A-Lago documents case. So, first of all, if he goes to court for recusal of Judge Tanya Chutkan, I would think that Judge Tanya Chutkan would deny that, and then he would appeal it, and then the appellate court would deny that because he would have nothing to show for it that she's made an outcome determinative ruling. And again, district court judges have broad discretion. And if Aileen Cannon continues to double down and ask the DOJ how and why it's doing its investigation without paying attention to the trial schedule or the trial or the discovery process and dealing with the mammoth case she has at hand, well, the decision is Jack Smith's of when to move for recusal of Aileen Cannon. And you will notice that Joe Biden is not going out and saying over and over again, no, recusal of Aileen Cannon, recusal of Aileen Cannon. No, that's not happening. It's not being politicized by Joe Biden. It's being politicized by Donald Trump and his legal counsel, John Lauro, and all the other people who are talking about Donald Trump and spreading every disinformation that Donald Trump is spreading. And because of the risk of that and tainting the evidence and corrupting the integrity of the criminal case in DC, the election interference case, the DOJ has come and asked Judge Cannon to issue a narrowly tailored protective order. And I believe Judge Chutkan will. And I believe that, so we'll just have to wait until Friday, thankfully, because Judge Chutkan is expediting and fast tracking and keeping to the speedy trial norms of our jurisprudence. With that said, I think that's all I have for y'all today. Hey, Macy, thank you for being here. Knowing Trump, he will still talk about the case. I think that he's going to find ways to talk about it, but I think the narrowly tailored protective order would blunt whatever he says in many ways. And also, one other thing that I would like to say. I would imagine that Judge Chutkan would impose the protective order, and if he violates it, don't expect don't expect Judge Chutkan to remand Donald Trump to custody. Expect Judge Chutkan to fine Donald Trump because she has that latitude to sanction Donald Trump. So, and it may be $10,000, it may be more. So there is that avenue. Don't expect that in this case, at least, in the election interference case, if he keeps on breaking the court's rulings and orders, that he will be arrested. I mean, of course, there is that possibility, but Judge Chutkan won't go that far. I believe that Judge Chutkan will impose heavy fines. And I think that would be the more prudent way to go, simply because it's less political and it still penalizes the person who clearly has the money to pay for it. So with that, thank you. If you're new to my channel, please like and subscribe and share with others. Hey, thank you so much again, Deb, for being here. And I hope that this gives you an idea of the spectrum that we're dealing with in how conservative judge is handling the case of Donald Trump and how a liberally appointed judge is handling. But if you look at their actions, you have to look at their actions of what has happened. Judge Chutkan was not admonished by DC Circuit for anything. while Judge Cannon, in this particular case, in its investigative stages, was admonished for abuse of discretion by the 11th Circuit Court of Appeals, which is the court that supervises, or which is the not supervises, the which is the higher court, appellate court above the district court. So uh, the distinctions from the get-go are gives you the auspice that it should be Cannon who should be recused, and still the DOJ hasn't asked for recusal. Okay, but Donald Trump is publicly demanding the recusal of Tanya Chutkan. These disparities, I want to bring that disparity, to you. I want to show you, because things get complicated with the orders and what's happening with the minute orders, and they happen fast, and they are technical, and people get lost. And I want to sort of bring it to an understanding. I'm going at 20 minutes now, that gives the layperson an understanding of what is happening. So, the part of me that is like my core, agrees with you, Macy, that just, lock him up and throw away the keys. But there's that legal rights thing that, Donald Trump has a right to a fair trial. Donald Trump has a right to counsel. Donald Trump has a right to a robust defense. And he's getting that. He's getting that from John Lauro. But I think, and you will, if you are interested, my previous episode is about John Lauro and his interview in Meet the Press, and how I believe that his lawyers going out and throwing out his defenses to see how they will stick is actually weakening Donald Trump's case and giving the DOJ more to game out, to war plan out. And I think that they're just digging their own graves. But don't tell them. Nobody tell them. And I just want to end with one thing. Well, two things. First, thank you so much for being here. If you are new to my station, my channel, my station be my chair. So please like and subscribe. And I forgot the last thing that I was going to say. That's what happens with live streams, y'all. But keep an eye on Judge Chutkan's hearing on the 11th, on Friday. Then I'll keep my eyes out for the ruling by Judge Chutkan, which will probably come that day, or if not early on the next day. And then keep an eye out for Aileen Cannon. Thank you so much, Macy. I truly appreciate that. Thank you. I definitely I appreciate any sort of donations that y'all would give. And so that made me a little shy. And okay. So thank you so much. And thank you, Deb, for being here. I'm going to log off now. If something else comes to my mind about these two, I want y'all to think about these two judges, right? And think about their actions. And that would help try to compare and contrast their actions in your head. And if you have any questions, please put them down in the comments after this video ends also, and I will definitely get back to you as well as I can. I'm going to focus more on the election interference cases and any other investigations coming out of that. I will keep an eye out for the Mar-A-Lago cases, but I will probably not go specifically into the rulings unless there's some really absurd ruling by Cannon and I want to read it to see if it's an appealable order. So Hey, Macy, yeah, we'll prompt my notifications. Thank you so much, Macy. Yeah, you can set the notification, the bell notification, and please share and subscribe. It really made my day today. And hey, Deb, look, Deb has been a constant supporter of mine for the last few months. And, Macy, you are, uh, I believe, the third person to donate, and I really appreciate it. I'm all, you know, uh, thank you for that. Anyway, all right, I'm gonna take off, and I'll come back to you when if there's need, and hopefully I'll try to be more lighting. And if you can hear my voice, yeah, if you can't, let me know. Take care.